My name is Carl Pearson, and I'm going to talk to you in this video about the AIG bonus problem, how the monies can be recovered, and also a proposal for partial bankruptcy as a way of solving these problems generally with many corporations. Recently, AIG, as you know, gave away about $1.2 billion in bonuses, or probably more than that, and had received an enormous amount, close to $1 trillion, I guess, will be coming up, or even more than that, in monies of the taxpayer going to AIG, and some of which, a small percentage, has been siphoned off in the form of bonuses at a time when AIG is a bankrupt corporation. AIG is insolvent equitably and legally, meaning that it can't pay its creditors as the debts mature, and it has insufficient assets of value to pay off all of its creditors. So whether it's an equitable test, meaning they just don't have the money today, or a legal test that their balance sheet shows that they don't have the value to pay off all their debts, AIG should not be giving out money in that magnitude to its employees and officials. AIG has thousands of creditors, including the United States and various bankrupt companies. Under American law, 3 creditors can file an involuntary bankruptcy against AIG, and any of the bonus payments made within 90 days prior to the filing of the petition would have been illegal preferences, with the AIG's trustee having the right as a matter of law to recover the payments for the debtor's estate. I believe that that is a fairly safe proposition. There would be arguments, on the other hand, that you can't do this to salaries, but these are not salaries. These are bonuses, and presumably would be based upon profitability rather than on illegal conduct. And if it's based on illegal conduct, the bonuses themselves would not be legal. To the extent that any of the bonuses are not deemed to be preferences, they are fraudulent conveyances because of the amount of money involved. The payment after a year of services, meaning that AIG was waiting to see how it did for the year before giving the bonuses, and AIG, instead of giving bonuses, should have been reducing its expenses and its compensation. Accordingly, by putting AIG in bankruptcy, the bonus problem should solve itself. There appears to be no difference between the U.S. government providing financing to AIG and the lender giving financing to a debtor in possession, and AIG might as well be put into bankruptcy where the rule of law can sort out the issues, rather than several people in the Obama administration who are inclined to give away trillions of dollars of the public's money. There's a long-range solution to the executive compensation problem across the board for many hundreds of large corporations. There are at least 4 classes of victims of excessive compensation: the shareholders of the company, the customers of the company who wind up paying more than they should because of the higher prices that they're charged, which results in higher profitability and excessive compensation. These illegal activities of the first corporation cause damage to competitors, and it causes a reduction in stock value so that the investors in the competitors are also injured as a result, at least in many cases. Under current law, the only persons having the right to go into court are shareholders, and for most shareholders, generally the public, there is little or no incentive for them to do this because they don't receive anything of any great value. It's a lawyer's action, basically, but it's not for shareholders. They don't make the money. And in fact, there is not very much litigation concerning this issue. I just looked in the case law and found that there are about 20 reported decisions per year in all federal and state courts. Now, that isn't very much, but that's what I found. And didn't even go into what the decision was, but the issue was sort of raised in about 20 cases a year. A better solution would be to enact a statute permitting the filing of an involuntary partial bankruptcy against the corporation by 3 or more shareholders, and it would relate only to the issue of executive compensation and not to anything else the corporation is doing, and let the bankruptcy court make findings about excessiveness and require the return to the corporation of excessive compensation with interest after determining that certain standards for excessiveness had been met. The legal theory would include waste of corporate assets, fraudulent conveyance, preference, unauthorized, breach of fiduciary relationship, unfair business practice. There's a variety of legal issues that could be raised in the bankruptcy court, as I view it. By stopping executive compensation, we might also be able to limit the illegality of business conduct by the employer, which usually accompanies excessive compensation, and this would be a blessing for consumers and for competitors. My name is Carl Pearson. I'm a lawyer who litigates in the areas of antitrust, civil rights, intellectual property, and foreclosure defenses and other commercial litigation. I have a series of useful videos on YouTube based on my experiences, which you can find by searching for CEPersVid. That's sort of like a trademark. Thank you.